And welcome back to the program. Thank you for staying with us. It's time for Opinion Court. Please do get in touch with us. 22422, that's our SMS line. And if you're online at Citizen TV Kenya or at Citizen TV News, I am at Ann Kiguta. That's Ann with an E. Please use the hashtag Opinion Court. We'd love to hear your feedback. I want to reintroduce my panel. To my immediate right is the chairman of the Orange Democratic Movement, John Badi. Next to him is Edward Kisiangani. He's our resident political analyst. Across from me, the national chairman of the National Alliance, Sakaja Johnson. You're all welcome to the program. As we have said previously, Kenya is seeking two things specifically at the Assembly of State Parties. The first being an agreement from the Assembly that Rule 68, the one that allows redacted witness testimony to be used in an ongoing case, that was not supposed to be used retrospectively, meaning that it should not be applied in the Deputy President's case and that of Joshua Rapsang. And then the second is Kenya's prayer that an independent panel of 5 jurists be constituted to probe the way in which evidence was collected in the Deputy President's case and that of Joshua Rapsang. And so I will start with you, Badi. What do you think of Kenya's two positions?
First of all, on the first one, on Rule 68, I think it's an embarrassment to our country. I say so because we have great lawyers, we have great diplomats. The government should have known when they were appending their signature on the inclusion of this rule that it was appropriate if they were promised, because I hear, well, I don't know whether it is true, that there was a promise that this would not be applied retrospectively. But then what stopped the Kenya government from pushing for that to be put in writing begs the question. Now we embarrass ourselves, we carry a delegation of so many busybodies. I call it busybodies because I really don't understand what those members of parliament have gone there to do. We needed just a few competent team of lawyers and diplomats to go to ICC to pursue this case belatedly. I hesitate to say, but to me, it's an embarrassment to our country.
But nonetheless, do you think it's an important push? Do you support it?
It is an important push. I'm only worried about the timing of the same, because now it portrays us as a country that is so selfish, and a country that, to me, is not pursuing justice. Why do I say so? It is quite obvious the reason why we are pushing for that rule not to be applied, and that exposes us as a country. Much as we want to protect the Deputy President, we should also save face as a country, not to be seen to appear as a country that is supporting impunity. Now, the other second case, I am one of those members of parliament who appended their signature, and actually I appended my signature very early in the day to have this matter relooked into. Why did I do that? I did that for two reasons. Number one, this issue of witness procurement and fixing of the suspects at The Hague was a hot topic in 2013 prior to the elections. And I wanted a system where this would now come out clearly, who did what, so that this matter does not go again. We don't go with it to 2017 and it's used for political campaigns. So for that reason, I felt there is need to do audit so that people can come out. Those who are claiming to have fixed others could come out and expose themselves so that we don't use this matter again.
Okay, what I'm not clear on is your position on the first. You're saying it makes Kenya look like it is not interested in justice. You're saying it is putting... Am I hearing you correctly when you say by going out, you know, in support of the Deputy President that way, that the Kenya government is in fact not pursuing justice?
If you ask me if I was in government today, what the government needed to have done was to apply some tact in approaching this matter. But you see, we are exposing ourselves. What we are saying is we know that if this rule is applied, unfairly applied, so because they are not saying that this rule may be applied unfairly, then that it would expose the Deputy President to serious justice, in which case there is fear of conviction. That to me exposes us as a country that only considers and thinks about the Deputy President and not the victims of the post-election.
You're saying it could be seen that way. Is that how you see it?
That is how I see it. Because you see, the moment now you go to ICC, because you feel that that rule is going to hurt an individual. Because there is no hiding about it. It's clear in the open. They're saying we are doing this because it is going to hurt the case, the Deputy President's case. And to me, I look at that as very irresponsible.
Okay, Sakaja, he says this is proof that the Jubilee administration is not interested in justice, and what many Kenyans may be wondering is, as you lobby for the Deputy President, etc., where's the ordinary Kenyan in all of this? The person who suffered in 2000, you know, in that post-election crisis. How does what the Kenya government is advancing at the ASP defend the interests of Wanjiko or Adhiambo or anybody else?
Thank you. First, I'll start from where the ODM chairman has left off. It is abundantly clear that the process that we're in is a botched process. His own party leader, the Right Honorable former Prime Minister, himself has said that the Deputy President was fixed, and he has actually presented himself and said, I want to be a witness, because he is accused of crimes committed as, you know, a member of ODM. And we'd expect to see ODM more in support, because they would know more as being the party that the Deputy President was in at that time and what he's accused of. But what does the ordinary Kenyan want? The victims, I've interacted with very many, they want justice. And our point is that we cannot get justice from an unjust process. And this process is manifestly unjust. If you look at the prayers that the Kenyan team that is there, and I think it's very well represented, what they're pushing for, it's very simple. Number one, Rule 68. In the 12th Assembly of State Parties, there was an agreement when the prosecution pushed for the amendment of Rule 68 to say that recanted evidence can be used. They said, and the agreement there, and it was on paper, it's part of the resolutions of the 12th ASP, that it will not be applied retrospectively or retroactively, you know. And what it means is this, just to make it simple so that everyone can understand, that today I'm a witness and I say that Anne Kiguta has committed the following crimes and she did this to me. But then later I say, okay, I was actually paid or I was forced to make these fake claims, don't use my evidence. But the court says, no, 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 even in as much as you've disowned your evidence now, we're going to use your earlier statement. There is no system of law anywhere in the world, not even Vioja Mahakamani, where you can say that today Kisiangani stole from me, then tomorrow is okay, actually he didn't steal from me, but the court says no, no, we don't believe you now, but we believe what you said before. Right. It never happens. So the real victim, the victims want justice, but true justice can only be found in a just process. If Kisiangani today commits a crime against me and Anne Kiguta is jailed, have I gotten justice? Justice will not be found by getting the wrong people. And we're saying, look, we want justice, but we want justice through a just system. Is there a guarantee from yourselves that should the ASP agree, if somehow the agreement of ASP would in fact guarantee an agreement by the ICC, and yet you're saying that we still want justice, there has been no evidence that this matter will come back to local courts and be discussed again for the kind of justice that you're claiming is necessary and is not available at the ICC. So which other court would Kenya be going to? A local one? A tribunal? We're saying, we're in the court process. Kenya has complied. In fact, one of the judges said that Kenya has actually exceptionally complied. Even the president went to the ICC. The deputy president has been going religiously. When he's called, he goes. His lawyers are there. We are complying with the ICC, but we're saying the court needs to be reformed in such a way that it actually adheres to the rules of natural justice. And the point is this, the ASP is actually the superior organ because it's the Assembly of State Parties. We are stakeholders. The position of Kenya in the Assembly of State Parties, because it's the Assembly of State Parties that actually created the ICC, the court. So the court is subservient to the ASP. So the ASP, actually 1/3 of the ASP already by now, which is the African continent, has rallied behind that position and said, look, if we have a court of international justice, it must be a just court. The second thing we're pushing for at the ICC is independent oversight mechanism. An independent oversight mechanism that will actually audit how witnesses were procured. I mean, ODM has said it even louder than us. Moses Kuria said it, but ODM has said that yes, Ruto was fixed, but he was fixed by so and so. They've admitted.
Right.
So true justice will only be found through a just process, and that is what we want.
Let me just make an intervention. This matter requires a lot of sobriety. The starting point for our discussion, Anne, is to say, how did we come to a point where Rule 68 was going to be amended? We came to that point because there was a crisis of witnesses withdrawing without any reason, and some people mysteriously just disappearing. And the international community was shocked by the way the Kenyan case was going. In fact, part of the reason why the president's case was collapsed is because of the crisis of witnesses. And so now it came to Ruto's, and it seemed that, you know, witnesses had problems. And you have seen so many people, a couple of people being mentioned in the media, that probably they belong to the camp of the deputy president and they might have corrupted witnesses. And then you have had the submissions. So it is not against no background. It's against a background of the crisis of witnesses. So that's where we start from. Then we go to Rule 68. And we shouldn't sound emotional in this matter. We just need to read Rule 68. Rule 68 does not have a caveat. It doesn't have a restraint clause, which says that it can only be applied in this manner.
Exactly.
So that is where the catch is.
Right.
If you go to make law, and then you make law, and then you don't include certain things, after you have made law, you go to the bar to drink. And when you are drinking, you agree that even if we made that law, we have in principle agreed like that. The argument that the Kenyan delegation is making does not hold water, because when you read Rule 63, that is the only one that we have as a legal document for the ICC. It does not talk about not applying retroactively. So what will be done is this. I think that there will be legal minds in The Hague tomorrow who will argue that yes, maybe you agreed informally, but the law that is
the letter of the law is different.
Then final I'll say this, because I really think sobriety is important here. That when you say you want to admit evidence, the most important thing is that the courts have not said that when you admit this evidence, it will be taken by the court. The court can still dismiss that evidence even after it has been admitted. Right. So the question is, why are people panicking? Because the court can still bring in the recanted evidence and then dismiss it with costs and say this is not correct evidence. But if you are persuaded that this evidence can hurt a certain person, then probably you are admitting guilt. As you respond to him, and perhaps I'll pose this question to both of you, because Mbadi, I realize you're a little silent in our conversation.
No, I mean, he's ready for his turn.
Then it should be his turn. But I'll put yes, fair enough. I know you want to respond. Even if ASP was to agree with Kenya on prayer 1 and 2, yes, what can it use to force the court to comply to the same?
The first thing, the court will definitely and must be bound by the rules set by ASP, because ASP is what set up the court. Number two, the
court has already told you just this past week that it's independent.
The court is not independent of ASP. The court was the creation of ASP. The Rome Statute was signed by countries that are signatories to the Rome Statute, including Kenya. Does it concern you that the judges sitting on this case have just told you in the past week that they're independent, regardless of what you say? They're independent in the decisions they make, in the application of the law. But the law they make, including the rules, are made by the ASP. All the rules actually... No, I didn't interrupt you.
No, I just want a clarification on that matter, because it's probably helping you, because Anne is asking the question, that is, what would the Assembly of State Parties do? What it can do is to initiate a further amendment to 68 to say now it cannot apply retroactively. That is what it can do.
That's the best.
Let me finish my point. Huh? It is the ASP that makes the rules for the ICC, because ASP is the Assembly of State Parties that constitute the ICC and they create the court. But what he has said is extremely dangerous. He is saying that at some point, Rule 68, and if you listen to it, he is saying that Rule 68 was actually amended because of the Kenyan cases. What does that tell us? It means that actually Bensouda knew, and in terms of jurisprudence, it creates a bad precedent that a prosecutor can actually decide to go and look for fake witnesses in any case. look for fake witnesses, give them evidence that they want, or whatever they create, and then later, whether they withdraw or not, because of their conscience or because they realize what they said was a lie, that evidence will still be used, if you can call it evidence. Secondly, what we're saying is this: we are actually partnering and you know, dealing with the court, cooperating with the court, but we want justice. Justice can only be found in a just system. There is no, and I challenge everybody on the panel today to tell me one jurisdiction in this world where evidence that is recanted, that is withdrawn, and it's not evidence of dead people, that is different. It's somebody who's alive who actually goes to say, Professor, that I was made to lie, I was bought, I am a fake witness, please disregard what I said before.
Very nice.
There is no system of justice anywhere in the world where such evidence can be used.
Buddy, let me come to you, and even as I'm sure you want to respond to all of that, you know, we've had the leader of the majority basically threaten walkout, that if you're not going to hear what we have to say tomorrow, then we're not going to stay where we aren't wanted. And Kenya has previously said that it can, you know, pull out of the Rome Statute. One can fathom that that could be possible, but what is the likelihood that the rest of Africa would follow?
First of all, I think that is an empty threat, because I don't know how strong Kenya is in terms of being a member of I don't see it, because the African nations will sympathize, will cooperate with Kenya, but to the extent of walking out may be difficult. But having said that, I don't know whether my colleague Honorable Sakaja is convinced with his argument that because even domestically we legislate to correct mischief. So when Professor mentioned that this rule was passed in 2013, doesn't it ring a bell? Because you see, even the prosecutor herself did mention that Kenyan case is a challenge to them, that they are dealing with, let me just finish, because they were dealing with unprecedented case where people are withdrawing, witnesses are withdrawing in numbers that they have never seen before. So it should have rung a bell to the Kenya government when they were participating in amending this Rule 68 to provide for a system where recanted evidence would be admitted. They should have asked themselves, how will it affect our case? Because the most active case at ICC at the moment was the Kenyan case. And that is why I say the government, the Jubilee government, is asleep. They started sleeping immediately they got into power. So in 2013, rather than exposing ourselves today, this is something that should have been sorted out. It would have been very simple. Provide in that provision that it is not going to be applied.
You don't see this going anywhere. You don't see success tomorrow. Do you? Allow him his chance. You don't see success tomorrow, do you?
Can I just conclude that even assuming that it was amended, that it will not be applied retroactively, what if the court also says, you have just amended the rule now, our case started before. The amendment, this amendment does not affect the case.
I want us to move forward.
I don't see any success.
We must move forward because we are also running out of time. But Prof, I think what Mbadi is saying in a roundabout way, it's not likely that we would see extreme success, at least in his opinion. If I'm not reading you wrong, tomorrow, I beg your pardon, Sakaja, we must move on. If Kenya fails to have the requisite support tomorrow at the ASP, do you see a Jubilee alliance under whichever banner, including President Uhuru Kenyatta and his deputy president, still viable if the deputy president's case is still before the ICC in 2016?
I think everybody knows, even the infantile political leaders know that the ICC case has held together Uhuru Kenyatta and Ruto in a big way. And so if something funny happens and maybe Ruto suffers, it will punch a big blow to that alliance. But if this case continues the way it is continuing...
Does it make the alliance stronger or weaker?
It depends on how Jubilee responds. Some of the work that is being done in The Hague is supposed to strengthen the alliance between Uhuru Kenyatta and Ruto. So it can continue for some time. But you can't predict for sure what will happen in the next few months. People can change positions, like, they come from The Hague and say, now we know who fixed who. It's a very dynamic thing. But what I wanted to tell you, Anne, is this. I mean, the panel is this. The African situation is very interesting. Now you can go and ask questions like this. While you are fighting so hard to serve two individuals, there is totally no local process. I don't think we can lose that. So no local process has even been initiated to serve the people who suffered as a result of the post-election violence. But we still hang on and say we are going to withdraw. The idea that has been put in place by I mean, the statement by Duale is reckless. It's a national disaster. You know, he must also know that when he comes here and tells us that he has withdrawn, the process of withdrawal is very big. First, the cases will have to go on as far as the Rome statutes are concerned. And then secondly, as the cases are going on, we need a referendum. We need a referendum to withdraw from this because,
to withdraw from the ICC?
Yeah, because Article 2 of the Constitution, which talks about the supremacy of the Constitution, says that all the rules of international law are part and parcel of the laws of Kenya. So to change that, we must take a referendum and let people say we are withdrawing from the international conventions, and that is going to take a long time. So it's not going to be an immediate thing. It's not a very easy thing.
First of all, Article 2 states that all, international agreements that we ratify are part of Kenyan law. In law, there's something called the hierarchy of laws. At the top is the Constitution. The Constitution of this country, Article 50, 2K, states that any accused person has a right to challenge evidence. What we're saying is that, yes, we're participating in this process, but true justice can only be found through a just system. Secondly,
justice defined by Jubilee.
Secondly, true justice cannot be found in a just system anywhere in the world. And I've challenged you, and I've not interrupted you, but I've challenged you to show me any system, even in your village, of the law, of justice, where evidence that is recanted or removed is applied. And I've given the example of Yuza Makamani, there's none. But the point is this: what you guys are saying, you've talked about infertile politicians and whatnot. I'll tell you, even jukebox professors anywhere in the world will tell you for a fact that the agreement in the 12th ASP meeting was an official agreement that is part of a resolution. It was not an agreement in a bar.
It's not part of the statutes.
It was part
of the statutes.
It was part of the resolutions by the ASP. Not everything is legislated.
Okay. Fair enough. I think, Sakaja, we've deliberated on that point, and it will be up to ASP.
I hope it is understood, and we hope that ASP will make a fair decision tomorrow.
All right.
It is not just the position of Kenya. It is the position of the continent. It's the position of 1/3 of the court, and we're saying that as Africa, as Kenya, we are stakeholders in the court, and if we feel that the court is actually unjust, that political machinations are being used to make judicial decisions, that is not a justice.
Let's see what Kenyans think about what we're saying tonight. It's unfair and just to use Rule 68. Evidence gathering was simply a fixing game. I concur with the government. I support Kenya's ICC push, but not to the extent of pulling out of the same. That would rip Kenya to rags. The issue of Rule 68 is under consideration by the ICC. Why not wait for the appeal? Let the ICC deal with the case without fear or favor. All we want is justice. Mr. Sakaja, because we know ICC is an unjust process, what has the government done since to give justice to victims? Which really just goes back to my question, I beg your pardon, goes back to my question, which if the ICC process was somehow to fall through, if Kenya was successful at ASP and they agreed and somehow even managed to push or bend the court to its will in some shape or form, how does that guarantee local justice? Because the perception persists that victims have not had justice.
Let me say this. And I gave the example earlier. Today, if it takes this phone of mine and you are jailed, does he get justice? When you get the wrong person, you don't get justice. Justice can only be found through a just system. That is what Kenya is pushing for. Number two, look at the case.
And how will we get the right person?
Look at the case of IDPs. First of all, most of the victims will be able, and Parliament made the wrong decision. In the Parliament you're in, whether or not which side was supporting it, we look at it as Kenyans. If we had a real local process that actually deals with the first perpetrators.
Are you saying you will restart a local process?
I think the real perpetrators, the people who killed,
you know them.
The people who maimed, I don't know them, but I'm saying whoever, the victims know. They know who came to their houses. They know who killed them. They know who did what to them. Those people must go through a process. You cannot have justice and saying that if so and so is jailed or not.
Honorable Sakaja,
well,
you're not answering my question. If ICC was to fault you, are you going to come back and stand in Parliament and say we need to start a local process again?
What I will say is that we need justice that is not necessarily retributive but restorative, because Kenyans need to move on. People need to reconcile. Restorative justice is the justice historically, and any law scholar will tell you that is the kind of justice that works within our context. Restorative justice, not retributive. But even in as much as you want retributive, the real people who committed crimes are known by the people who are the victims. This government has resettled 90% of IDPs. IDPs have been a problem that the past government of Raila and Kibaki never dealt with, has been dealt with in less than 2 years.
Bati,
can I just come in? First of all, even the resettlement that Honorable Sakaja is talking about has been done with a lot of unfairness, and then expecting Jubilee government to do any justice, I don't think is overstretching the imagination. But
it's not about resettlement.
The only issue left is integration.
Please allow
you realize that a lot of other communities in this country suffered, probably even much more than the communities that have been settled. But no one thinks about them. They are being called
What is the evidence of that? We hear that allegation a lot by your coalition. What is the evidence that it's
what he's saying is partly true.
Certain communities.
First of all, we have statistics. We know in terms of deaths which community lost the largest number, at least for the reported cases. We know the numbers. I don't want to go to the specific ethnic communities, but some of those people have never been considered, and there are people who are also displaced wherever they were and have not been considered. But what I wanted to say in terms of what action would we take as a country, for me, I think the most important thing is if we could have Truth, Justice and Reconciliation Commission.
I'm glad you mentioned reconciliation.
I'm talking about that because right now this atrocities happened in 2008. If we were committed to bringing the culprits to justice, we would have initiated investigations, because with the passage of time, the investigation may not be as thorough as we expected. And therefore, what we need to do is to have a commission where Kenyans can come, like Kuria now came forward to apologize and explain himself or herself. We would want a system where Kenyans now come together and say we did wrong, and I apologize to the people I did wrong.
And you're saying going back to the same TJRC that was constituted?
It could be another TJRC, so long as if we were committed. The problem is that we form TJRC, which we are not committed to implementing its resolution.
I hear you. I'm going to come round.
If we were genuine as a country, that would be the right way to go.
I hear you, sir, and I want to come to a final round of comments, and again start with you as we watch the developments over the next few days, and it could go either way. What should Kenyans keep in mind?
For
Your
me,
final
my final comment is, if we wanted this country to heal, we should do it differently. Let us not come together in a bipartisan way. Treat this matter politically, because what we want is a political settlement of this matter, and come up with a system where we can reconcile and heal. But trying to use the legal framework and going to the ICC as if we are going to threaten them and carrying a huge delegation, I think we are just making a mockery of ourselves as a country, and I don't think it's very good for the image of this country, especially given that we were part of the team that ratified the amendment to Rule 68, unless, and this is my final ones, unless, and I'm sure probably that is the objective of this, that we are trying to play politics for 2017.
But you just said we should sort it out politically.
No, the political settlement I was talking about is that we accept as a country that we need to move forward, not to win elections.
Okay.
If we are doing it to win elections, then it is unfortunate.
Fair enough.
Yes. First of all, from what I said, Kenya as a member of the Assembly of State Parties is there by right. And our delegation has been extremely successful. Even the fact that our agenda has been put from just being part of the supplementary to the main agenda, and we're getting a lot of support. And I want to really thank the delegation that is there. They're doing a great job. Secondly, even as we deal with what happened in the past, we must be able to look towards the future as a country. How do we move together? Part of the reasons and the problem that caused what happened last time was hate speech. How are we dealing with hate speech? For example, within our political parties, we have members from both sides of the divide who sometimes have made statements that incite. For example, I have a member in my party who actually made inciting statements. I took him through a disciplinary process. When a member from your party, and I'm glad it's the chairman who's here, made that statement, he was escorted to the police. When Alado made such statements, he was escorted to the police by the party leader. What message are we passing on to Kenyans? That actually we can tolerate this. If we want to unite this country, we must begin. Thirdly, I'm glad he's spoken about truth, justice and reconciliation, because what is important to our country is how do we bring Kenyans together. The victims cannot have justice through an unjust process. You guys have actually accepted it's an unjust process. Your own party leader said that he wants to actually testify for the deputy president. Why can't we use this as an opportunity, not just to rally Kenyans together, but also to make sure that this never happens again by providing real justice? If you are committed to a bipartisan process that will actually give us more of a future and look forward to how we can unite our country, I can tell you today that I will be part of that and we will move our country together. But if you want to do it for political expediency, then we will not be part of that.
I think for me, what I would say is that withdrawing from the Hague, ICC court is not an option. We should still remain there, because that our presence in the Hague, our membership in the Hague, saved us from conflict in the 2013 election, after the 2013 elections. But secondly, the way our African leaders are presenting themselves, I think the Kenyan delegation should pack up very quickly and leave the Hague quickly. In fact, because it's a shame. And let me finish first. It's a shame that they don't even know that what they are going to argue tomorrow is not in the statutes of rules. They are arguing so they are going to argue about what was passed in Aba, but not in the law. It's not that. But finally, I want to say this, that it's so ashamed that now when these guys come they talk to their colleagues from Latin America and other places, and then their colleagues ask them, but is there anything you are doing at home? And they say no. They've not said no. The most interesting part of it, as I end, is this. Even the cabinet secretary for foreign affairs is now saying he will ask for prudent use of resources. Yes, and prudent use of resources from Kenya.
Yes, we are
from Kenya.
We are contributing to
now you know how to use your resources, but you can't use the resources here. Now, prudent resources contribute
to the ASP.
On that note, we're going to wind it up here.
Kenya tomorrow, what does he think of the future?
Ask him another thing. That would be a can of worms. Thank you all. Thank you all so much for your very sober views this evening. We're back with more a little later in the bulletin. Bye-bye for now.